This is India's #1 news network, and you're watching News 9. English news as it should be.
Hello there. Thanks for tuning in to your favorite news destination. You're watching In Your Interest with me, Kabir Naqvi, and on the first segment on the show tonight. For years, we have been told that our private conversations are locked, they're encrypted and safe from prying eyes. We were told that what happens on WhatsApp stays on WhatsApp. But tonight, that foundational trust is facing its greatest challenge yet, both in the highest court of our land and in the international halls of justice. In New Delhi today, the Supreme Court of India drew a firm red line for WhatsApp and its parent company Meta. Chief Justice Surya Kant issued a warning that should shake the boardrooms of Silicon Valley. He said, follow the Indian constitution or exit, leave India. The court is looking into the controversial 2021 privacy policy, a policy that forced users to accept data sharing with Meta without any option to say no. And whilst WhatsApp argues it's just a platform, the court sees something more clinical. The judges called the commercial exploitation of your private data a clever way of committing theft. And this isn't just about targeted advertisements, it's about dominance. The Competition Commission of India has already slapped a 213 crore rupee penalty on Meta for abusing its position. They have been ordered to stop sharing user data for advertising for the next 5 years. And this ultimatum comes on the back of a global class action lawsuit filed just days ago in the United States. It claims that WhatsApp's biggest selling point, end-to-end encryption, might be a myth. That's right. Based on whistleblower testimonies, the lawsuit alleges that Meta can actually access your messages internally, including real-time chats and even those that you've deleted yourselves. Now, WhatsApp's core privacy promise is now under serious question. Trust is eroding, especially in key markets like India. Public figures and influencers are amplifying these concerns, which could push users towards other rival applications. And for Meta, the risks are quite real. Possible user churn, more lawsuits, stricter regulations. I mean, we're talking about pressure on its stock as well. With 854 million users in India alone, the stakes have never been higher. India is Meta's largest and most strategic market globally. If the Supreme Court stands firm and the encryption claims prove to be false, well, the very future of how we communicate is at stake. An esteemed set of panelists with me on the broadcast tonight. Big questions that we are trying to decode. Can a global tech giant be allowed to operate in India if it refuses to provide an opt-out clause for its Indian users? And with 850 million odd users in India relying on WhatsApp for business and personal life, can India actually afford to push Meta out? Or is this the leverage needed to force a global policy change? Take a look at this. Amit Dubey, cybersecurity expert, with me on the broadcast. Professor Dr. Nisha Nujumuddin, public policy analyst, also with me here on the broadcast. Mr. Dubey, let's get the ball rolling here. The Supreme Court used unusually strong language. Exit India if you can't respect privacy. The Supreme Court, it didn't mince words. If you can't follow our constitution, if you can't respect it, well, the doors are open. Kindly leave India. Is this the strongest warning ever issued to a global tech company that's operating in India? Less than a fortnight ago, it was you and we were talking about the United States lawsuit as well. And now, take a look at this. The top court of the land has taken it up as well.
I think this is the strongest reaction of any CGI which we ever had against intermediaries. And kind of warning, actually repercussion of the case that we discussed in US. where the company Plentech has actually filed a lawsuit, including representatives from 4 different countries: India, Australia, Brazil, and different other countries. So first of all, I think we have a right to know that what kind of data these intermediaries are.
That seems like a technical snag with Mr. Dubey's connection over there. I'm going to quickly bring in Professor Nishan Najumuddin. Your opening submissions, Professor. The court has called WhatsApp's policy, quote unquote, a decent way of committing theft of private information. How do you look at this?
Basically, this is it's not a tech versus debate. This is a citizen concentration of power debate. I would say India is not the WhatsApp ka existence. It's questioning how the patents are being used by, also its parent name. So privacy is absolutely non-negotiable, no doubt. If you see input to some privacy is the fundamental right under 21. This is privacy information. It also has consent. Consent which is taken is not a consent, right? And now we need to understand that again, law, which we all know, the Act of 2002. Again, it has the market dominance with the company also, I would say, because this so-called WhatsApp, okay, the WhatsApp or Meta, as they say, even when the NCLT penalty was upheld also, the WhatsApp leverage dominance. This is not something. It is, and now.
I think you're making an incredible point here, Professor. There's some audio difficulty with your connection as well. I'm going to quickly request the control room to check that up as well. Mr. Dubey, I'm going to quickly come back to you. We lost your signal over there. Please complete your opening submissions and your thoughts. I mean, we're talking about the court that's flagging metadata here, and they also picked up about how a doctor talks about a particular medication, and then minutes later you see that advertisement on your phone, and I mean, something's got to give. Something is being leaked. Now, what it is, well, only time will tell. We're waiting for that interim order that's going to, I think, come on the 9th of February. But your opening submissions, apologies for cutting you short earlier.
So I think, first of all, we need to understand that Meta is having an extra advantage because Facebook or WhatsApp, they both are for different purpose, but by any chance, they say that WhatsApp is not listening you, but Facebook is listening you. Yeah. They can actually do a lot on WhatsApp, pushing you advertisement or showing you something which you may be surprised to see because they have been getting your voice access through Facebook. So that kind of interchangeable data access is being used by Meta for many reasons. And I think this is something which has been raised as a concern. We should know what kind of data they are collecting. For every user, if you would like to check what Facebook has been collecting about you, you would not have checked ever. You just go to Play Store and type Facebook over there. You will have an icon, click on it, and there's an option called data safety. And click on see details icon, and there you will see that what kind of data Facebook has been collecting from the device. The data is that they are listening you all the time. They know your religious ideology, they know your political ideology, to whom you voted last time, they know your health record, your financial details, they know your contact details, your Facebook, your pictures, videos, anyways, your locations, your addresses, so many details. And SMS and emails, every access they have. Now, this is surprising. And you don't have an option to block it. That, okay,
so the court is absolutely right. The court, when it says that this is a decent way of committing theft of private information, I mean, the court has kept flagging metadata. How explosive is that observation coming from the court? And do you think we're going to be looking at some serious changes in that interim order?
Of course, I think there should be an option because privacy is our fundamental right. And we are just ensuring that every user should be protected through that right, that law. And because we don't have an option to block that access of data or to regulate it, and that is a bigger concern. Because if they know so much about me, eventually they can control me. They can predict things about me before I get to know. And this is much more scary for me. Sometimes I get things which I have just imagined in my mind. I have not even discussed with somebody because they have been following me, chasing me, listening me, or watching me for a very long period. And this is the biggest concern, especially when somebody is at very serious critical position or senior position. And if something happens against them, this can actually lead to much more serious disasters. And that is, I think, is applicable to a large extent to each and every one, because, as I said, the privacy is our fundamental right, and we need to ensure that. If
100%, 100%, Mr. Dubey. I mean, consent versus coercion. You know, back in the 2020, 2019 update, you even had the not now button. You don't even have that button anymore. And, you know, when pretty much most of your business life, most of your professional life is worked upon WhatsApp, is it really an option to press, no, I don't want this? Everybody's got to use WhatsApp in one way or another. I can see Professor Najumuddin, who's back with us. Professor, most Indians hear end-to-end encryption and they assume WhatsApp is completely private. Your privacy is absolutely intact. In simple terms, what exactly is protected and what is not protected? Encryption does not mean privacy now, doesn't it?
Yeah, they talk about encryption, but you need to understand that data is power and not a freebie, right? Now, this meta actually, the data, they can reveal the behavior, the political inclinations, and the economic vulnerability to it. So the messages are private, but the metadata, they are predative, and prediction is power. So now they even the big tech or the industry, they will come and argue that to the government. They will even say that service is a free agreement. What is claiming not fee and that, you know, free service does not mean free to the personal life, because free is not, free is not free when the currency is your privacy, right? It cannot be appreciated no matter whatever justification they give. And people also 21 is indeed very important. And when you talk about the global, if you see global practice argument also, if you see globally, policies do exist. That is what Meta is also saying. But now policy do exist, but we have to safeguard them. That is very important. And that is what our country India is demanding. And now, if you see the other countries, when you have a quick comparison with other countries, be it the European Union, be it the Germany, or be it the Australia, again, everywhere when they make a comparison, they need to understand that India is not an outliner. It is just aligned with the global domestic democratic standards.
It's the biggest market,
not at the cost of its privacy of its users.
It's the biggest.
Right.
It's the biggest market. Yeah.
Yeah, and you know, you see, we need to be very clear, and we have to have a balanced approach. Is what I see. India technology. India welcomes global platforms, and we welcome innovation. But India will not outsource citizen rights to corporate terms and conditions. That is what the Supreme Court is actually asking us, I would say. Because do business in India, they can do business in India, but do it constitutional limit, which is very mandatory. India is absolutely a wonderful market, no doubt about it. But therefore, you need to remember that it is also
and you need to respect that market as well. Mr. Duggal, Chief Executive, AI Law Hub, with us here on the broadcast. Many thanks for taking out the time, Mr. Duggal. This is the message only to Meta, or do you think this is a broader warning to all the big tech platforms operating in India? How are you looking at the developments and you know, some of those top quotes from the top court? WhatsApp argues that users have consent to that policy, but under the Indian law, is consent valid if it's buried in a complex, you know, web of language and that most users can't understand? The court themselves said, I mean, an uneducated person in rural Bihar is also using WhatsApp, and we sitting here in the top echelons of society can't understand your policy. What is that person going to understand your policy about?
Clearly, what the Supreme Court has said is nothing but mirroring the hopes and aspirations of the people of India at large. Also, the kind of comments that come from the Supreme Court are nothing but indicative of one fundamental message that's loud and clear to all stakeholders, which is that if you have to operate in India, you will have to comply with Indian laws. You will have to respect Indian privacy, Indian fundamental rights under the Indian Constitution. And what the Supreme Court has said is nothing but also a mechanism to strengthen Indian cyber sovereignty. Why? Because when you are coming to India and you are making the data of Indians as guinea pigs for purposes of monetizing the same, it's time that the topmost court in the country comes in and says, you can't do that. Why? Because it could also prejudicially impact the enjoyment of cyber sovereignty, security and integrity of India. So it's something that was coming quite some time back, but this comments now coming from the Supreme Court have
So,
given
Mr.
a
Dugal,
new
Mr.
figure.
Dugal, India has a data protection law, but I mean, it's not fully enforced yet. We still have to wait and find out what happens on the 9th of February when that interim order comes out. So, today, help the viewers, help them understand what law is really protecting Indian WhatsApp users. It's such a huge market, about 850 million. Is it the competition law? Is it the constitutional privacy? Is it a mixture of both? Or do we need something more in terms of reform here?
Let me begin by giving you the not so good news,
Okay.
which is that Indian WhatsApp users are not at all protected in terms of having effective remedies under applicable law in India. Why? Because the Digital Personal Data Protection Act has not yet kicked in terms of implementation. Why? Because the Information Technology Act 2000 does not talk issues pertaining to protection of privacy. Why? Because the IT rules 2021 are relatively silent on what kind of remedies the users can have in the event their privacy is going to be violated. Yes, the grievance redressal mechanism dispute process is available, but we know for given fact that even if you raise a dispute under the grievance redressal mechanism, the result is known to you at the time when you file it, that it's bound to be rejected, it's bound to be not accepted. Why? Because it's a de facto norm of the company that let them come up with as much data as possible. It's something like, it's like the gold heist that's taking place. They know India has not yet come up with strong laws. Let's try to collect as much data from Indians, from India, so that we can then keep on using them till eternity for purposes of monetization of the same. I think it's time that the government needs to come up with effective remedies to users. And the Supreme Court warning is nothing but a noise, a shout in that particular direction. And I think till such time you don't really strengthen the lay users of WhatsApp in terms of having effective remedies in the event their privacy gets violated, we are all beginning to continue to keep on seeing Indians and their data being used as guinea pig data.
Looks like a huge uphill battle, Mr. Dugal. I mean, awareness creation amongst 850 million users is a mammoth of a task. But a quick follow-up before I go back to Mr. Dubey. Another legal aspect and viewpoint, if the court does rule against Meta, what kind of penalties are we talking about? What kind of penalties and punitive measures are realistically on the table here?
Well, first and foremost, there are no specific penalties. Yes, the Supreme Court has got absolute jurisprudence, absolute jurisdiction to impose as much penalty as the Supreme Court would want to do that. Why? Because Supreme Court will have to come up with an order which is proportionate, which is necessary in accordance to the facts and circumstances of the case. And there's no impediment, restriction, bar of any kind whatsoever on the power of the Supreme Court to impose as much fines as possible. As far as the law is concerned, the law does not give much kind of remedy. Why? Because the DPDP Act is not applicable. Had it been applicable, they could have been actually fined 250 crore rupees for one contravention. Under the IT Act, they can at best be fined for certain offences, but the fines are ranging from 1 lakh to 10 lakh rupees. I think the Supreme Court is right now the enclosure of all eyes of all Indians. Everybody is looking to Supreme Court as the savior of Indian privacy, of Indian interests, and the rights of Indian users.
I think that's also the problem here, Mr. Dugal. You see, I mean, we welcome big tech to our home, but we're too reactive. We only react after the damage has already been done, and that's something that the critics have pointed out as well. Mr. Dubey, if using WhatsApp is essential to daily life, something that I was talking to Professor Nujumuddin about as well, is accept or leave, the two options apparently that Meta gives us. Is that really a choice? If a user must accept a policy to continue using the application, which, like I mentioned, we really, really do need, can that consent ever be considered really free? And does India have enough space to welcome rival applications? There are quite a few, there are quite many, but in the Indian subconscious, in the India's socio-economic zone, I mean, WhatsApp takes the game away.
I think this mindset has already been there. If you notice around, when people are ready to discuss some confidential things, or they are indulged in some private communication, they don't rely on WhatsApp. They normally ask people to choose some other application. This has happened earlier also. So this kind of mind shift is happening, and people are opting the other options. So this is a big concern for WhatsApp. They need to ensure that whatever they are claiming how are they proving it? And if the data is going out through any means by end users' mistake or by platforms' vulnerabilities, it is a big issue. And that's why there are other competitors those are mushrooming up. There are almost 100 plus applications those are giving you much more security. They are giving you much more confidence, and people are relying on it. They are using it. So this is definitely giving a shift to the other options. Second, even if it is mostly used chat application, you can't enjoy the data access just because of monopoly. You will have to give the option, and I think this is our fundamental right.
Yeah.
If I don't get that option to not share this data, this is my fundamental right, which I'm just expecting from WhatsApp or any other platform for that matter. It is not just WhatsApp. I'm just making it very generic that any application that you have in your phone, they all are collecting your data. They all should give you this option that if you want to use that app without sharing your data, you should have that option, which right now is not there. So any such law, any such judgment which is there, it is applicable for all the applications. I'm not against just WhatsApp or any such particular because we are using WhatsApp, so we are discussing WhatsApp. But the court is concerned for any kind of data theft by any other application as well. So this will be applicable. I think this is a warning to all, any other application for that matter. They are even coming up with competition of WhatsApp. This will be applicable for them as well. So for end users, I think we have a mechanism that I have just shared. That go to Play Store, search that application, whatever you are trying to trust, see this what data they are collecting. If you are okay with that data, if there's an option to disable that data access, then you please use it. Otherwise, there is no such law right now as Mr.
For
Gupta
any
has said.
application that I download on my phone, it gives me a little pop-up that says ask application not to track your movements, not to track your data. And that's a clear-cut, option that you get on at least 90% of iPhone applications. I'm not sure if that's the story with Android, which is where Play Store comes in. But, the Chief Justice himself said that WhatsApp users are quote-unquote addicted and they have no real choice. Mr. Dugal, looking ahead, what should an average Indian expect? You earlier spoke about, creating that kind of awareness that the, grassroots level last end user should know what the application is actually tracking in terms of data collection. Are we looking at more control over this data? Should there be clearer opt-outs? I mean, what more can the government here now do? Or just, tougher language with no real change on the ground? That's what we've been seeing. The 2016 policy, we've got it going on our screens also, had the not now option. The latest policy, the 2021 privacy policy, only has the agree option. It doesn't even have a disagree option.
So clearly, we need to be doing a couple of things as a nation. Number one, the government of India needs to come up with new rules under Section 87 of the Information Technology Act 2000, specifically mandating what kind of safety parameters and precautions it wants applications like WhatsApp to specifically follow in the context of protecting the privacy of Indian users. Number one. Number two, I think we need to have specific provisions where these fines up to 250 crore rupees could even be invoked independent of the DPP Act in the context of the IT Act ecosystem. Number three, the government needs to come up with strong public awareness campaigns asking Indians to be conducive, to be stingy about their data. Let's not use any kind of an application which is making us as a guinea pig, which is using our data. And finally, it's time to encourage Indians to not be completely intoxicated with these newly fascinating apps, but rather protect their data, because it's this very data that's going to determine their digital present and digital future. And in addition, the government can also stipulate that all these service providers must mandatorily expend 90% of their total CSR funds in the direction of making people aware about the privacy-related ramifications of their apps. Ultimately, users have to understand, they have to be selfish, they have to be stingy about sharing information. Information needs to be shared on a need-to-know basis, and they must be suspicious of every application till such time they have not read the terms and conditions and not read the privacy policy. At the end of the day, everybody must contribute in creating a more cyber-resilient mindset for Indian users, so that in the event today it's WhatsApp, tomorrow it will be ABC, day after it will be some other application. Whatever application comes in, Indians must be consciously clear that we should only share as much information as is necessary, and not necessarily blindly rely on such apps.
You're absolutely right, Mr. Dugal. It's just that, it's easier said than done. How do we do so much in so little time when, the entire world is getting digitized, and we're talking about artificial intelligence. There's a special chapter on it in the economic survey as well. The final say to Professor Najumuddin, we can finally see her on the broadcast. Professor, messages may be encrypted, but behavior, contacts, timing, Mr. Dubey was talking about political inclinations and the likes, your religious information, usage patterns, they still have massive commercial value, and maybe that's being siphoned off. Is encryption alone a sufficient defense if your user behavior is being monetized?
As my previous speaker spoke, and as you even said, I strongly believe that in India, the constitution is the ultimate privacy policy, no doubt about it. That is where Article 21, which talks about right to life and privacy. Article 14, where there is equality and there should be no coercive content. But what we are seeing today is a kind of coercion rather than a kind of consent, right? And again, the abuse of dominance is very clearly stated in Competition Act of 2002. And again, in 2023, we had the Digital Personal Data Protection Act. And all these are with the purpose of limitation, data minimization, and informed consent. So when we have all these, we need to really abide by that. As I mentioned previously, also see, even the global platforms, they do have all this. Meta can compare India with them. But we need to understand India is not an outliner. It is aligning with global democratic standards, but not at the cost of selling its own privacy, which is very, very important. So at the end of the day, as again, once again, I would love to say that let any company come, let anybody do business with our country, India, but you have to make sure that we do it within the constitutional limit, because we are therefore a republic.
And like the top court said, with the right kind of respect that this huge marketplace should get. US lawsuits that Mr. Dubey and Mr. Dugal and I, we were discussing just a short while back. The EU fines, and now finally India, the pressure on Meta is converging worldwide. Mr. Dugal, Mr. Dubey, and Professor, many thanks for taking out the time and speaking to us here on In Your Interest. The court effectively is saying that dark patterns exist, confusing design and language, they are unconstitutional. Is encryption alone sufficient defense if your behavior is being monetized? It seems the judges now are recognizing that metadata can be as invasive as the messages and the content itself. Well, something for you to ponder. We're going to slip into a quick commercial breather here. Our second segment coming right on the other side.
इम्तियाज जी के फादर को बीमारी के कारण अचानक हॉस्पिटल में एडमिट होना पड़ा। पॉलिसी बाजार की टीम ने हॉस्पिटल पहुंचकर लाखों का क्लेम अप्रूव करवाने में पूरी हेल्प की। पॉलिसी बाजार पर 1 करोड़ का हेल्थ इंश्योरेंस सिर्फ 550 रुपए महीने से शुरू।
घर है वही जहाँ सब संग हो, रिश्तों को रंग दो, दुनिया को रंग
Birla Opus Paints. Sometimes it flows like water, light and free. Sometimes it stays grounded like the earth beneath. Sometimes it sparks romance. And sometimes it grows into an evergreen togetherness. Senko, Elements of Love.
Every champion's journey starts with second